Hello, welcome to JMW's Inside Man YouTube channel. Please subscribe to the channel to hear more legal hints, tips and guidance. And please also like the video using the button below as well. Now, a man has been called bald. There's been a legal case around it. To explain a little bit more is Grace O'Driscoll. Grace is a solicitor within JMW's Employment Law Department. So Grace, what exactly happened in this case?
So this case was Finn and British Bung Manufacturing Company Limited. And in this case, the tribunal held that calling a man bald is sex-related harassment. The ruling was made on the basis that hair loss is much more prevalent among men than women, and therefore a comment on such could be regarded as being related to their sex. Tony Finn, who was the claimant, worked for the respondent, the British Bun Manufacturing Company, for 24 years before he was dismissed in May 2021. He brought a number of claims, and this harassment claim was one of them. Allegedly, Tony Finn had an argument with his supervisor, Jamie King, in July 2019, in which King had referred to the claimant as bald and had also used an expletive. Finn argued that he was less upset about the language that had been used and more upset about the comment on his appearance.
And so what did the judge find, and why is it surprising, Grace?
So the judges, there were a panel of 3 of them, and they all, interestingly, were bald themselves. They deliberated as to whether this was simply an insulting comment or alternatively if it could be harassment. The ruling stated that it's difficult to conclude other than that Mr. King uttered those words with the purpose of violating Mr. Flynn's dignity and creating an intimidating, hostile, degrading, humiliating or offensive environment for him. They further commented that the remark was inherently related to sex. This seems to be a surprising decision on the surface, as many wouldn't consider describing a man bald as likely to amount to sexual harassment. However, it's important to look towards the effect of the behaviour on the individual and whether it clearly created a hostile or degrading environment. Here, the panel found that the comment had affected the claimant in that way and there'd been a harmful intent.
And I mean, I'm allowed to say this because about myself, but I know a little bit about not having much hair. What can employers take away from this, and how can you help?
So the case really is another warning for employers about passing comments, anything that could be classed as banter or heat of the moment jabs, and the fact that these can have lasting effects on individuals and may be damaging to the working environment as well. So companies should really be providing all employees with effective bullying and anti-harassment training, as they will likely be vicariously liable in cases where comments like this are made in the workplace. Companies should also be sure that they're encouraging managers and those in more senior positions to handle situations appropriately, as this could certainly avoid tribunal claims. It can be seen in this case that there was likely no effective management in delicate situations, as that's the kind of situation where this comment was made, and it hadn't been regarded as a serious matter. Obviously, I'm sure the company now is regretting that decision. If you'd like assistance in dealing with any advice about delicate employee situations or training in regards to anti-harassment or bullying, then we'd be able to help.
Excellent, Grace. Thank you very much for your time. If you would like to contact Grace, you can email insideman@jmw.co.uk or call her 161 82 81 999. I'm Dominic Walker, JMW's Inside Man.